Thank you so much for joining me in this video lecture. This is Gurpal Singh from Gursur Education. And as you all know that we have already covered a lot of topics under business environment and international business. We have talked regarding the introductory lecture, then economic policies, and then industrial policies. These all things we have already gone through in detail. So in this video lecture, we are going to cover the specific topics regarding the legal environment of a business in India. And specifically, we are going to cover three major laws which have been given in our specifically in our syllabus as well, and which are also very necessary to go through for understanding the legal environment in India. So these are going to be Consumer Protection Act, and after that Competition Act, okay, which replaced the MRTP, and after that we have to study regarding the Environmental Protection Act as well. So these things we are going to cover in details. I shall be telling you when they were formed and what are their objectives and what is there to learn to us, okay. So all these things shall be discussed in this video lecture. I hope you have got the idea or the structure of this video lecture. So I hope you would enjoy this video lecture. I'm just going to share the screen and just to see that. All right. So now in this video lecture, we are going to talk about what we can say is most important. And this is going to be regarding legal environment of a business. Legal environment of a business. So as you know that we are going with the series regarding the video lectures of business environment and international business. We are doing the topics regarding these two major subjects, okay. So in these series, this is the most important thing I would say, that we have to cover one by one all the different business environments, okay. I have already delivered the basic lecture regarding business economics in which we categorized the business environment into two parts. Basically, we have covered internal and external business environment, and in external, so how did we categorize? If you remember that lecture, business environment, it was categorized into two parts. The first were internal environment and the second were external environment. And we categorized the external environment into two parts. The first was micro environment and the second was macro environment. And at that time I taught you whatever is included in macro environment, we have to study all these topics in detail in upcoming video lectures. So the first lecture was regarding economic environment, which we have already covered, okay. So in this video lecture, we are going to talk about legal or political environment. And when we talk about this, we usually mean the Consumer Protection Act, the Competition Act, and Environment Protection Act, because these have specifically been given in our syllabus. Although, if we go through from legal environment or political environment in depth, then this particular topic do not have any kind of end. It cannot end. But luckily, we have been given a very short listed topics which we have to cover, which are named as Consumer Protection Act, Competition and Environment Act, and Environment Protection Act. So if you learn regarding the basics of these, regarding the structure of these, and how these are made up, when they were made up, and what are the objectives for which these three things were made up. So if you go through from these, it will be much more than sufficient from our example point of view, okay. So now we are just going to cover this topic right now. I hope you would have got the idea and the structure regarding what it is going to be in today's lecture. So first we shall discuss about the Consumer Protection Act. After that, this act, this is Competition Act, and then Environment Protection Act. And if this lecture do not if we are not able to cover these topics in this one video lecture, then maybe we shall be taking the next lecture as well. And today we have planned that we shall be taking some more videos, lectures as well, because I have to teach you regarding new economic policy as well. So these have been allotted this particular day, although these topics are not supposed to be covered right now because we are already advanced, but I feel that we should give some more things, some more stuff for you, because exams are just arriving right now. So the first thing we are going to talk about is Consumer Protection Act. Okay. So whatever we are going to teach you right now, that would be sufficient enough. Okay. So what is Consumer Protection Act? Just for the sake of saving, just for the sake of saving the consumer from any kind of fraud, the Consumer Protection Act was passed in the parliament. Okay. So this particular act was passed. So and it was passed in the year 1986. Okay. So this particular act was passed with some special provisions and some special sections, just in order to save the consumer from any kind of a fraud, which I have already taught you. Okay. And how he can save himself in case he feel that he is being defrauded by any of the seller. Then he has been given three options to sue the party. He has been given three options to sue the party or the seller of the goods. Okay. These three are the different commissions. These three are different commissions about which we have to study. Okay. So first of all, I believe that you would have got the idea of why this particular act is there. So this act tried to protect the consumer not only for goods but also for services. Okay. Consumers in the act means any person who buys any goods for consideration or hires or avail any services. So there are two kinds of a consumer given in the definition under section 2 of a Consumer Protection Act. So just for the saving of saving their lives or just saving their interest, this particular act was passed in the parliament. So if we take the definition, then we can easily get to know that this act applies to both goods and services. For both goods and services, it has covered. Okay. The provisions of this act are applicable even when part payment has been done. If the buyer has not made the full payment, still this case is applicable. Still he can sue in case he feels that something is not being done good to him. Then this act protects not only buyers, but users as well, in case of goods and services, and beneficiaries as well in case of services. So not only buyer, even the final consumer or the final consumption man or women, which are known as users or beneficiary, they are also being given the opportunity of being heard in case any kind of torture or any kind of defraud has been done against them. Then there are major two councils. Okay, there have been two councils for protection of the consumers. Okay, although there have been three different platforms in which the person can sue, the buyer can sue, but there have been major two councils. Okay, which can ultimately be responsible for applicability of this law. Okay. The first is the Central Consumer Protection Council and the second one is the State Consumer Protection Council. So these are the description regarding these two, why we have included these in this specific lecture. The only reason being, one or two times we have experienced that these are asked in the examination. Okay, like for Central Consumer Protection Act it was asked, and for state as well it was asked. So what is this? I hope you would have got the idea what are these for. These are just for making sure that all the sections are being applicable to the full extent. Okay, for just the sake of application of the law in their jurisdiction, these councils have been made. The first is a central and the second one is a state. By name you would have got the idea. Central Consumer Protection Council is just which takes into consideration about the about the administration of this law at the jurisdiction of a whole of India. In case of a state consumer protection council, that deals with a specific state. So how it is made up? Central Consumer Protection Council has been constituted with the following composition. There is always a chairman who is a Minister of Consumer Affairs in central government. Okay, he is the chairman of Consumer Protection Council. Then there is official and non-official members as well. Their numbers have not been prescribed in the act. And it is the discretion of a central government. They can appoint as maximum members as they feel that they are necessary for being members of a Central Consumer Protection Council. In the same way, there is prevalent the State Consumer Protection Council as well. This is established by state government by notification. Okay, the minister in charge of Department of Food and Civil Supplies in the state government, he shall be the chairman of this council. And after that, there shall be some official and non-official members, which the number of which can be prescribed by the respective state government at that time. So I hope you have got idea. Now, till now, what we have studied, I am just making the conclusion. Okay, after that we shall move further. I have taught you regarding Consumer Protection Act, what it is, what does it covers, and how does it save the consumers. After that, regarding definition, we have made some kind of clarifications. After that, we have learned regarding two different councils, and we have got to know their composition as well. Now, there are some redressal agencies. I have already taught you that under Consumer Protection Act 1986, there are some redressal agencies as well. Redressal agency as well means that when you feel that there is any kind of defraud being happen with any kind of a buyer, then what they can do, they can simply sue the seller, and they have three options to sue the seller. The first way is the district forum, the first court, we can say in the language of a layman. The very first court in which the buyer can sue, this is district forum. The second court is the state commission, and the last one is the national commission. One by one we shall be talking about all these, and that would be sufficient for us to study this particular topic. So the first is district forum. Okay, so what does it cover? Any complaints for goods and services which are for worth 20 lakhs or less than that. These kind of cases are handled by district forum. I hope you have got the idea. So any kind of complaints for the goods and services which have the value of 20 lakhs or below than that. So these kind of complaints shall be entertained by the district forum. This is the most important line. You must, I must tell you, if you can't remember, just cram it. This is very important line. Number of times these kind of questions, these kind of very tricky questions are asked in the examination. How is district forum made up? There is a president, okay, and he who is or has been or is qualified to be district judge to be nominated by state government. He shall be the president of district forum. After that, person of eminence in the field of education, trade or commerce. Okay, so the person should be there. Then a lady social worker should also be there. So this is the composition of district forum, and what does it do? It just entertain the complaints for goods and services worth 20 lakhs or less than that. The second one is a state commission. Okay, so what does it do? When the complaints are more than for 20 lakh rupees, but lesser than 1 crore rupees. So these kind of complaints are entertained by state commission. And what is state commission? State commission is just like a code. Okay, this is just like a code, like district forum we have studied. It has a judge who just give his decision. Okay, he can give the decision for the parties, and both the parties have to agree with that. So it can consist of a president again and 2 other members as well. The president must be retired or working judge of high court. They all are appointed by the state government. So this is all regarding the state commission. That would be much more than sufficient. You are not supposed to go through from so much detail. Just this particular law is extremely big, I must tell you, but we have to study only from our exam point of view. The first I've taught you district forum, the second state commission. Okay, the state commission, in case the aggrieved party is not satisfied with the judgment. Okay, suppose the judge has delivered his judgment, but the aggrieved party or the buyer is not satisfied with the decision given by the judge, then he can file an appeal with the National Commission within 30 days by depositing this fees or 50% of a penalty amount, whichever is less. So this is the condition if the party is not satisfied with the decision given by the state commission. So that was one of the condition which we have to understand. After that, here comes the role of National Commission, and this is the third commission, third kind of a code given in the Consumer Protection Act. What does it do? It just entertains the complaints worth more than 1 crore rupees, where the fraud is involved for worth more than 1 crore, that these kind of complaints can be entertained by national commissions, I must tell you. Okay, so National Commission consists of a president as usual and 4 members. One of them shall be a woman. They are appointed by central government. Then the complaint can be filed in National Commission if the value of goods exceeds 1 crore, and if again the party is not satisfied with the decision given by the judge of the National Commission, what you can do, he can just file an appeal or complaint within 30 days of judgment. To whom? To Supreme Court. He can file his appeal, he can file a complaint to Supreme Court within 30 days of judgment. So this is, I think that should be sufficient for just one law. We have to move further, some further laws as well. So what we have taught you, I think if we are making, you are not supposed to forget anything. Okay, you must remember everything. These are very important, I'm telling you, because whatever we are teaching you, that you have to go through. Extra whatever you can go, whatever you wish. Okay, so Consumer Protection Act, buyers, their classification, then definition, expansion, Consumer Protection Council's most important things, then their composition, after that the redressal agencies, their composition, and what do they do. So these kind of things you have to understand in this particular law. Now the second law is going to be regarding Competition Act 2002 and MRTP Act 1969. Yesterday I took the lecture regarding industrial policies. I taught you that there was the word used, import substitution. Import substitution. The Indian government passed this particular law, MRTP Act, in 1966, that was named as Monopolistic and Restrictive Trade Practices Act 1969. and it was enacted to ensure that the operation of economic system is fine, okay, because no seller could gain the position of monopoly or monopolistic position in the market. No one could be able to get that kind of position. Just for sake of that, there were so many restrictions to trade, so many restrictions, and these restrictions were defined in the specific act that was known as MRTP Act 1969. But at the time when in 1992 new economic policy was taken into force, okay, which I am going to teach you after this lecture, okay. So when it was came into force, then there was a realized the need of making or opening up our economy, Indian economy, to the world economy as well. So three basic measures were taken: liberalization, privatization, and globalization. And one of the byproduct, we can say one of the byproduct of these policies was the replacement of MRTP Act with Competition Act 2002, because there were so many restrictions for doing the trade in India. So what the government did do, they just they just abolished this act, and instead of this act, one new act was passed by the parliament, and it was named as the Competition Act. So MRTP Act was superseded by the Competition Act 2002. It was the history. I am telling you history as well. What is this? This was enacted by parliament, okay, and it governs the competition law, how the competition shall run. It replaced the MRTP Act 1969. Under this legislation, Competition Commission of India was established so that it can prevent the activities which have the adverse effect of a competition in India. So the thing is same, monopolistic and restrictive trade practices, but its name was changed, and so many relevant sections were changed so that the business could be run smoothly without any kind of restrictions. Then Competition Act was amended so many times, okay. First it was amended in 2002, then 2007. What does amendment mean? Amendment simply means some of the sections in the act were abolished and some of the new sections were inserted so that it could be smoothened further as per the contemporary norms of the country. So what does it cover? What does this specific law covers? Okay, it prohibits the agreement or practices that restricts the free trading. So the first purpose of this particular act is it just prohibit those kinds of agreement or practices which restricts the free trading and also competition between two business entities. So if there is a competition, if there is any kind of agreement which restricts that kind of free trading and competition, then this is completely prohibited by this specific act. The second is it banned the abusive situation of the market monopoly. So no one should be in a position to create the monopoly as per this act. The third, it provide opportunity to entrepreneur for competition in the market so that newcomers can come up, okay. Startups can be there in the market, because this particular act provides an opportunity to each and every entrepreneur in the country. The next one for this is to have international support and enforcement network across the world. Why all these things were done? This is very obvious, because when we started the new economic policy of LPG, there was a pressure from the international institutions like IMF, World Bank, and World Trade Organization that you have to change your laws. So this was also the reason why we have changed our laws after 1992. You can simply experience that in 1992 so many institutions were made. whether you are taking the Security Exchange of Board of India Act, whether this is National Stock Exchange, so many institutions were newly made after 1992, and these were all as per the lines, as per the suggestions given by the world economies. So international support could be taken only if we are doing these kind of things. Then it also it had also the objective of preventing the anti-competition practices and to promote fair and healthy competition in the environment, in the market. So what does anti-competition practices means? I'm going to tell you these right now. Anti-competitive agreements are of two types. The first are horizontal agreements. Okay, these agreements emanating from the collective action of a group of person engaged in the same line of business activities. Okay, so it's a common form of these kind of anti-competitive agreements are like price fixing, limiting the production, bid rigging, collusive bidding. Okay, so when there are two major players in the market and they are just making the collective action that we have to fix our prices first of all, or if we do not get the desired price, then we shall limit our production. These kind of things are just anti-competitive, creates the anti-competitive environment, and this was prohibited by this act. And these kind of competition in which same line of business activities involved, these are known as horizontal agreements. This next one are vertical agreements. These are those in which not the same, but the different types of systems are there, but still there is a cartel. So this type of agreement emanating from action between enterprises or person at a different stages or levels, such as producers and distributors. So someone is producing something and the other one is distributing the production made. Okay, is distributing. If they both person are making a cartel, so that the supply should be shortened in the market so that its prices can become high. So this is also known as anti-competitive or anti-business environment. So how they can do these kind of things? They can make a tie-up agreements or exclusive supply, exclusive distribution, refusal or a deal to resale price maintenance agreement. These kind of things just disturb the market agreement environment, and these kind of agreements are known as vertical agreements. Okay, so this act tried to reduce these kind of agreement. It was also the one of the objective of these. Then under this act, this is very obvious thing. Okay, one thing I am going to tell you right now, if there is any act, then it's very obvious that there would be a commission made for the application of that particular act. In the same way, there was the Competition Commission of India, and this is a statutory body of the government of India. It was established on 14th of October 2003. It became fully functional in May 2009 with Dhanendra Kumar as its first chairman. So it was somewhat history of a Competition Commission of India. Then its composition, it has a chairperson and 6 members as the complete formation of a Competition Commission of India. And I think this is the last topic, and under this particular topic, this is the functions of commission. What does it do actually? Although we have gone through objectives of this specific act, but these are also some, these can be further categorized into functions as well. These are somewhat similar to that, but we have just included these as well so that you get the knowledge and you revise whatever we have already done. Okay. So function of this, it eliminates practices which are having adverse effect on competition. So this is the first one. Then it tries to inquire into certain agreements and dominant position of enterprise. It also performs these kind of things. Then it tries to inquire into combinations. What does combination means? Combination, again, the collusiveness of two or more sellers in a way that they restrict the supply in the market. This is known as combination. Then reference of an issue by statutory authority to commission. If reference is any kind of reference is given to this specific commission, then they inquire into that as well. In the same way, a reference by commission, okay, so they also give a reference to some statutory bodies so that they can also inquire, because all the things are not done by commission itself. There are some other tribunals as well to whom the responsibility is also enshrined. Then power to issue interim order. It can give any kind of order against any kind of a seller or any parties. Then competition advocacy. It always try to maintain the competition advocacy. It advocates by giving its judgment so that the fair practice could be ensured in the market. So it advocate all the sections enshrined in this specific act. So I think it was all about that. So if we are making the conclusion of that, what we have done in this, first of all, I gave you some historical perspective of this particular topic. So it just replaced MRTP. Why MRTP was there? We have already studied. After that, there was need of opening up of our economy. This is why Competition Act came into force. This thing we have learned. After that, it was amended so many times. Then what does it covers? So it has some basic objectives which we have covered in this video lecture. And after that, I have given you knowledge regarding what the anti-competitive agreements are from the point of view of this particular act. And after that, we have studied regarding horizontal, vertical agreements. Then competition commission we have studied, then composition and functions of commission. So now what we have to do, this is going to be the last one. After that, we shall see what we have to cover in the next lecture. This is going to be regarding Environment Protection Act. There is not much to learn regarding this specific act, okay, because they are not going to be very specific, but whatever are necessary, like to save our environment, what have been the different legislation, you must know the knowledge, you must have the knowledge regarding all these acts, okay. So all these have been covered in short notes in this video lecture as well, and in detailed notes as well. So what is Environment Protection Act? This was passed in 1986, and it was passed by the parliament in the wake of Bhopal tragedy. The government of India enacted this act, okay. So it was passed under the article 2253 of the constitution. It was passed in March 1986 and it came into force in November 86. It has total of 26 sections. Then its purpose is obviously to implement the decision of United Nation Conference on Health and Environments, or on human environments, okay. So that is the, so why I have written this abbreviation, the only reason being sometime one or two time I have experienced that these kind of abbreviations are there in the examination as well. So this is why we have written that. So the purpose of this act is not manifold. So the basic purpose of this is just to implement the decision of the United Nations Conference on the Human Environments. So now just going to give you a detail of some environmental legislation in India. Okay, one by one you have to remember everything, and one by one you have to write their names as well. Whenever you can do that, and you have to remember in your mind what are the different kind of environmental legislation in India. So the first one was in 1905, known as Bengal Smoke Nuisance Act of 1905. Then after that, Bombay Smoke Nuisance Act of 1912. Then in 1912 again, Wild Birds and Animal Protection Act was passed. After that, the Rivers Board Act of 1956 was passed for interstate rivers and for just a sake of saving our rivers. And after that, the next thing was the Water Prevention and Control of Pollution Act 1974. It was passed to deal with water pollution. And after that, we can see that Water Prevention and Control of Pollution Cess Act 1977 was enacted. So it provided for the levy and collection of a cess on water consumed. So that's why if you pay cess as well along with your water bill, so that was enacted in under this particular act. Okay, so now you have got its knowledge as well. So after that, we can see that here was the act passed in 1981 named as Air Prevention and Control of Pollution Act. After that, the Environment Protection Act, obviously, which we have studied, and its objective we have already covered, that it has to apply the recommendations or the things given by United Nations Conference on the Human Environment. And after that, we can say that there was a Wildlife Protection Act 1972. It provides for rational and modern wildlife management. And after that, Forest Conservation Act 1980 was passed. It was enacted to check indiscriminate or deforestation, diversion of forest land for non-forest purposes. So for these kind of things was these were basically passed. After that, Public Liability Insurance Act was passed. Okay, so it was passed for mandatory insurance for the purpose of providing immediate relief to persons affected by accidents occurring while handling any kind of hazardous substances. So you can experience that if anybody is in the mining activities, like workers are there, so they have to do their mandatory insurance for under this particular act as well. Okay, so these are some of the things which we have to cover. After that, National Environmental Tribunal Act 1995, and it seeks to constitute a tribunal with benches to award compensation for damage to persons, property, and the environment arising out of any activity involving this kind of substances. These are hazardous substances. This is known as National Environmental Tribunal Act. You are not supposed to go from these individual acts in detail, but these things are too necessary. Okay, the things which we had to cover in detail were only three. Okay, and these were basically the first Consumer Protection Act, and after that the Competition Act, after that the Environment Protection Act. And I must tell you right now that although we have covered all the things necessary for these particular acts, but still we shall be providing you the PDF notes. That this is very obvious. On daily basis we do that. You have to go through from these as well. I have experienced that some of the students are not regular with these things. Okay, so we can call you anytime. We can check as whatever the level of your preparation is. So this is just think like tomorrow is your examination. On this point of view, you have to cover each and everything. Why you can see in the schedule that this topic has not been assigned this particular day. Okay, there are already 5 to 6 days. We are advanced with 5 to 6 days, and I wish to do these kind of things. I wish to advance for 10 to 15 days at least, so that we can cover a lot of things, because exam has been preponed, so we have to do these kind of things. So I hope you have got the idea regarding the next lecture. If we are taking, that shall be regarding new economic policy, and we are going to cover these topics like liberalization, privatization, and globalization. If the lecture is taken, then we shall be informing you within 15 minutes. Whenever it is taken, we shall be informing you the time. Thank you so much for joining me. This is Gurpal Singh from Gursar Education.